of numbers that you're looking for, many of those, of course, juvenile records are sealed. So you can't dive into that fact because without a court order. But I just know of those two and others like them that have been tried in district court and not in circuit court. So those are the examples I can give you. And unfortunately, in our district, I know in Jefferson County, it's unfortunate that that's happened more and more than we would like to admit. But
May I continue, Mr. Chair?
Yes, go ahead.
Thank you for that. I think that we all can come up with 1 or 2 or 3 or 5 or 6 examples. But as we are creating policy, it is so important that the policy that we are creating is based in real data. I know from my experiences of working as a court designated worker, ALC keeps this data. And what I would recommend to not only you, but members of this committee is that when we are creating policy, especially as it relates to incarceration or what we need to do around gun violence or any type of violence, we should be creating that is based in real data of what is happening. And so for me, that is a little frustrating.
And I would like to
hold on. Let me continue, please. That is a little frustrating that we are doing that, and I know that we recently just changed this because kids were automatically being referred up. And from my experiences, if there's 5 kids and one has possession of a firearm, and that one says it's my gun, from my experiences working as a court designated worker, all of those kids were automatically being waived up. And when we changed that law, we changed it because we knew that wasn't the correct way in which we need to be creating policy. So again, my issues is that we are continuing widening the net. And when we're talking about victims and what is happening, 123 JCPS kids have been impacted by gun violence. But we, as this body, as the judiciary, or we as the all of the General Assembly, we're not putting money into resources to make sure what are we doing for our kids who have been impacted. And so for me, I will be a no on this. And again, I do think that we need to do something with gun violence. This bill is not going to do it. I know that myself and several others have filed at least 5 or 6 bills that would deal with gun violence, and I look forward to working with you all on that.
Thank you for that question, and I do share some of your concerns. These statistics that I used came from the Kentucky Juvenile Justice Department and the National Juvenile Justice Violence Crime Report. And so those are being addressed. As your concerns with the number of, say, 4 or 5 individuals that are involved in the crime, and there is one person that uses the gun, that was discussed with the chairman, and that is addressed in the committee sub to where it is only the person that is actually using the gun that is transferred. So those concerns have been addressed, and so I do believe that when you look at how many victims are out there because someone has committed this violent crime, those victims and their families weigh heavily in our decisions to go this route.
Representative Burke, you're recognized.
Thank you, Mr. Chair. I have a question about the substitute bill, and I want to make sure I'm understanding correctly. I am looking at Section 4, Part B, subsection 2. So this is page 2, lines 14 and 15, and then subsection 3, subsection B. So lines 23 and 24. The interplay of how a reverse waiver would work. So what this says, for those who don't have it in front of them, is that there's a mandatory transfer to circuit court, and that happens when A, the child's committed a class A, B, or C felony, and B, they used a firearm to commit the felony. But then to effectuate the reverse waiver between the Commonwealth's attorney and the judge, the circuit court has to find that less than 2 of the factors specified in KRS 640.10 have occurred. Now, I've cross-referenced to 640 Part 10, subsection 2, Part C. Number 1 is the serious of the alleged offense. So an A, B, or C felony is as serious as it gets
Yes,
by
ma'am.
definition.
It is.
So that's 1. And then number,
I'll leave this one for you to talk about discretion.
well, I'm trying to find it. There's one that says, oh, number 10, if you used a firearm in the commission of the offense. So that's 2. So the way I'm reading this, you can only send the child back to district court if you find that less than 2 factors favor circuit court. But by definition, there are already 2 factors. So if the judge applies the law as it's written here, they can never send the child back to district court unless they make a finding that a B, or C felony is not serious.
And I'll comment on that, Senator, and thank you for the question, Representative Burke. That mirrors the language that is currently used. So if the district court makes 2 of findings in 2 of those 10, the case is sent to circuit court. So I think there are some factors that could militate against potentially a reduced charge could occur with the prosecutor. There's a possibility that the judge, circuit judge, could conclude maybe a gun wasn't used, but that's the language that's currently used by the district court to determine whether or not to send a child to circuit court to be tried as an adult. So it's just mirroring that same language, just to clarify. And sorry for interrupting you. You may continue.
Thank you. May I comment on the bill?
Yes.
I understand that that is how you refer from district to circuit, but we've created new law here. And the way that that's going to interplay, it sounds like the court or the prosecutors or the police had to make a mistake. They had to be wrong. There was no gun in order for a child to be sent back to district court. Or we've overcharged that child. So again, a mistake on behalf of the prosecutors. I want for us to do better with children's gun violence. That is incredibly important to me. In Fayette County, what we're doing is working, and it's not this. And I really respect our district court judges who are working with kids and the programs from our city government that are working with kids to reduce gun violence. This is going in a direction that I'm very uncomfortable with, particularly you can't just mirror this language because it doesn't work in the reverse with this new statute as it's drafted. Unless somebody made a mistake, then that child is stuck in circuit court. So it either has to go up to less than 3 factors, or you have to change the factors by which they're referred to circuit court in the first place. That inconsistency in the substitute must be fixed in order for me to even consider it. Thank you.
I think it works perfectly, so we'll agree to disagree. Representative Moser.
Thank you, Mr. Chairman, and thank you very much for bringing this legislation. And I'm glad to see my friends, Colonel Morgan and Ryan Straw at the table and others. Thank you very much for your work. I think the committee sub answers some of my questions and concerns, and so thank you for working on this so diligently. And I just want to thank you on behalf of the victims in my district, the family of the 14-year-old who was shot. We have to do better. We have to advocate not only for the kids who are finding themselves in trouble for this kind of behavior early. You don't find a stronger advocate than me for kids in the juvenile system. But if a child has used a weapon in the commission of a crime and has killed someone, these statistics are troubling. And to see this kind of increase just tells me that we have to do more. So I appreciate your work. I appreciate the conversations that we've had prior to this, too. And I just want to give you an opportunity to maybe talk about this, because I know that this is a concern that some of my colleagues share, and it's addressed elsewhere. But is there an opportunity to also hold the parents accountable for the child's using a weapon that's registered maybe to them, or allowing access to that weapon in the commission of a crime?
Thank you for that question. As you have seen here recently, parents were held responsible for a child that committed a heinous gun crime in a school setting. So this bill, that may be something to address in another bill, but this bill strictly deals with the accountability of the juvenile that is using the gun. I do not disagree with you, and I am wholeheartedly with you on holding their adults that provide these guns or access to these guns accountable as well.
Okay, thank you. Mr. Chairman, if I can just follow up.
Yes, go ahead.
I've had conversations also with Ryan Straw about this. Do we have provisions that allow for holding parents accountable, or I know we were talking about the younger children who had gained access to a father's weapon. It was a 3-year-old who shot his 2-year-old sibling, and I mean, it's heartbreaking. But I think that those parents were held accountable, and I know we're talking about 15-year-olds here in this bill. So do we have laws that allow for some of that?
We do. So existing would be unlawful transaction with a minor. And not looking at it in front of me right now, it may not be sufficient, but there are tools for that, and there's gradations on, are you allowing your child to be a truant, or the more serious, not that truancy isn't serious, but have you provided access to a gun? So there are those tools. Maybe they're not used enough, and maybe those need to be looked at a little more too.
Okay. All right. Thank you.
Mm-hmm.
Representative Flannery.
Comment on the bill?
Yes, go ahead.
Thank you, Mr. Chairman. I really don't understand why this is so controversial. What we're talking about here is violent offenders that are using firearms to attempt to murder or seriously injure people. It gives a preference to prosecution in circuit court, where there would be more punishment. And not only would more punishment not only be appropriate in most of these situations, more importantly, it creates, hopefully, fewer victims or less victims. When you have serious violent offenders that are locked up, that keeps them off the streets and keeps them from doing this to our family members, our loved ones, our neighbors, people that we care about, or people that we may not even know. And I really am having a hard time understanding what the heartburn is about this. I mean, I think we would all agree that, there should be stiff punishment when you kill someone or attempt to seriously injure someone, and I proudly support this bill.
Representative Stevenson, you're recognized.
Thank you. I have a couple of questions, but one of the things my 86-year-old uncle and aunt were at the post office on a date, just getting mail. And a young person with a gun approached them, and they decided that rather than give them the car, they would drive the car into the post office. So this is not a question, don't make it a them or us, everybody wants to live in a safe neighborhood.
Yes, we do.
Everybody wants their children to be safe. So it's not about that. And everybody wants police officers to be safe so they can keep the peace. It is not about that at all. What we want it to be about is something that's effective, that will work. So my question is, does this bill address in any way the availability of guns to people that is so widespread?
It does not address the availability of guns, but I can tell you this: if we continue to send these violent offenders back into our neighborhoods and don't hold them accountable, we are encouraging our citizenry to defend themselves. We are encouraging them to go out and to buy guns themselves, putting more guns in our neighborhoods. Because when you feel your neighborhood is unsafe and your children cannot play out in front of your house and you are threatened by gun violence, you have a choice to make: to arm yourself because you have lost faith maybe in the judicial system. Not
Exactly.
locking these people up, not holding them accountable, encourages more guns to be purchased.
Exactly. Lost faith in the judicial system. I was at a neighborhood association meeting, and they wanted to know, what are you doing about guns?
This is
Why are
what
there
we're
so
doing.
many guns? Why aren't you bringing any legislations so that people can't just walk in and get a gun and 2 days later shoot somebody? So my question is, our system is built on rehabilitation. We put you up, we put you away, you come out a better citizen. What services are in this bill to deal with why those kids are crooks?
I would be glad to entertain and look at any bill that you would like to bring forward, but this bill does not address those issues. This bill simply addresses holding those accountable that are committing the most heinous A, B, and C felonies with a gun. If you would like to bring a bill that addresses those other issues, I would be more than happy to entertain those bills and to read those bills, but those aren't addressed here. But we do have tremendous amount of investments in prevention efforts to avoid these type of crimes. We have invested over $50 million as a Commonwealth for intervention strategies. So I would say that we are doing those things, but in this situation, when those things aren't effective or are not working for this niche group, we owe it to our citizenry to hold those folks accountable and to do all we can to keep our neighborhoods safe.
And no one is saying don't hold people accountable. I want them to go to jail if they're to hold them accountable. We're questioning the most effective way to do it. This is a public protection problem. We're clear about that. And we have experienced from your own testimony that more, higher, better sentences haven't worked. You said crime is going up. We've been increasing the felonies and doing all of that for the last several years. It's not working. So holding them accountable and the talking points are great, but we're really interested in what would make the difference to get kids off of this track. I've never met a 2-year-old that said, when I grow up, I want to be a crook and a criminal and kill people with a gun. So at what point do we intervene before this is too late? Hold them accountable, but what are you doing so they don't get to this point? And I don't see any bills for that.
I think you've addressed the question, Senator, so thank you, Representative Stevens and Representative Kulkarni.
Thank
You're
you, Mr.
recognized.
Thank you, Mr. Chair. Senator, you just mentioned that there was $50 million going to intervention services. Can you clarify that or expand on that?
Yes, when I inquired with staff about how much we have invested in intervention strategies and programs, youth programs over the years, and I believe in the last budget that we had over $50 million assigned to intervention strategies, whether it be school-related programs or after-school-related programs, or those intervention strategies and behavioral therapy programs that we hope would curtail some of this. So that's where I've got that number from.
Brief follow-up, Mr. Chair.
Yes, go ahead.
Can you tell us how much funding has been allocated in the budget?
I cannot right now because it's in conference committee, and I would be remiss if I jumped ahead of the conference committee in between both Senate and House and predicted what number that would be.
Okay, one more question, Mr. Chair.
Go ahead.
if you would. I did have a question, and we haven't really discussed it, about the fiscal impact of this legislation, which is significant. Defined in this document as over $1 million. And that is largely because we are locking more children up. I mean, I know the term violent offenders has been used, but the bill itself specifies children and child.
Youthful
locking
offenders.
Them up, locking them up for longer periods of time and locking more of them up. So could you go through exactly what the estimated cost would be for
There's
this?
no doubt that there is an increased cost when you incarcerate people, but I would ask you, what's the price tag for a 12-year-old's life that was killed by juvenile gun violence? What price tag do we put on the continued victimization that is the direct result of juvenile gun violence? What price tag do we put on an 84-year-old man who simply sticks his head out of his side of his door at his home when he hears someone breaking into his car and asks what's going on out there, and he's shot at by 3 juveniles? What price tag do we put on the trauma and the PTSD that that man will live with for the rest of his life? So yes, there is a cost, but I say that cost is well spent.
So my concern is not necessarily.
So are you asking to
Sorry,
be
one more.
recognized for another question?
Yes, please, Mr.
You're
Chair.
recognized.
My concern is not about anecdotes. We could talk about those all day. My concern is about where we're actually gonna detain these individuals, how much law enforcement personnel. My concern is the capacity and the bandwidth to actually implement this if we don't have that money being allocated in the budget for it. So it's an unfunded mandate. We are requiring more from our law enforcement. We are requiring more from our court systems, and we are not talking about how we're going to be funding them. Thank you, Mr. Chairman.
My answer to that would be that these violent crimes are being dealt with in the courts today. And yes, this may move more into the circuit court, but we are paying those costs now. And as I said before, the cost is greater when we don't address the issue.
Thank you. There are some individuals who have signed up to speak in opposition to Senate Bill 20, and I'm going to recognize those folks at this time. So the first person I will recognize is Mike Conway, Kentucky Free. And I'm going to, let's take about 5 minutes, Mike, if that's okay. And Mike's from Danville, so he has the misfortune of being one of my constituents. So welcome to the committee.
I'm grateful. Yes.
Good to see you.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and members of the committee. I'm Mike Conway with Kentucky Free, the Kentucky Forum for Rights, Economics, and Education. Our comments today are more constructive suggestions, I think, than opposition. Our organization appreciates the efforts of the sponsors to address juvenile justice issues in the Commonwealth. We, however, feel Senate Bill 20 should address the youngest of first-time offenders, those under 15 years of age. When a young person first commits a low-level crime, it is imperative there be consequences, not jail, but wraparound services such as mental health and family engagement. Most youth, again, under 15 years of age, who interact with the criminal justice system for the first time have serious emotional and mental health needs. It is important that these young offenders don't get thrown back into a bad situation without individualized, family, and youth-directed, community-based focused services. It's vital for a youth offender to be evaluated not only for mental health needs, but his or her unique family situation. Families need to have access to what services are available and what services are needed. Consequences for juvenile crime need to include the entire community. The best way to prevent youth recidivism is to make certain families and communities are partners in leading the direction for our youth. In closing, Mr. Chairman, we appreciate the many efforts made in this bill to address juvenile justice, but let's remember, without total engagement, the system simply reinforces that there are no consequences for the youngest offenders. Again, 15, 14, 13, 12 years old even, eventually leading to repeat and more serious crimes in the future. The goal needs to be connect with children and families before these kids are the ones with guns. Thank you so much.
Thank you very much. And I'll next recognize Jason Hall with the Catholic Conference, who is also a con on SB 20, or an opponent. And you have 5 minutes. Thank you.
Thank you, Mr. Chairman. Jason Hall, Catholic Conference of Kentucky, members of the committee. I just have a couple comments about Senate Bill 20, and I've had a chance over the last little while to look at the committee sub. I do want to say that I appreciate the amendment the change clarifying that it has to be the defendant who used the weapon. I think that was a constructive a change, but we do have one concern does remain, and this has been touched on, but I just want to add hopefully some clarity to it. This bill does not add, in my understanding, and I'm open to correction, but as I see it, it does not add a single case, real or theoretical, to the universe of cases that can be transferred to circuit court. The factors which have been discussed, the 10 factors, can, upon motion, be considered by the judge. If there are 2 or more, they may transfer. Under the current statute, the 2 is a minimum, which then gives the district judge, discretion on whether to transfer after considering all the factors. The seriousness of the offense and the use of a firearm are 2 factors which have been mentioned. Other factors are the best interest of the child and the community. Whether the child is a defendant with a serious intellectual disability, which has to be considered. Under this bill, those factors could not be considered by the judge. And as was pointed out, the circuit judge could not consider those factors if in a decision whether to send it back, because they could only consider whether 2 factors were present. So I would urge you to think about that and to be very careful, and please make that change. The judge needs to have the discretion. I would ask, what is the purpose of removing that discretion? The ability to consider mitigating factors as to the culpability of the juvenile defendant. It seems to me that's why we have judges, is to weigh those things. So thank you for your time, and I strongly urge you to be very careful with those changes. Thank you.
Thank you, and I would just disagree with your assessment. The judge could consider all 10, so that's not correct.
Well, I would, if I could,
So
can I respond? I mean,
sure.
I just want to be very clear
I mean,
that
it references the statute that the district court would use. So the district court, if the district court makes a finding of 2 factors, then it would go up to circuit court. So it's just the same in reverse in the circuit court doing the analysis. So I would politely disagree with that assessment.
may I?
Sure.
I would just, if I can just read it, it says, if finds that 2 or more factors specified are determined to favor transfer, the child may be transferred. Maybe.
You're talking about the district court.
Yes. And whereas on the reverse in the committee sub, that's the current statute. On the committee sub, it says that the defendant may be sent back to district court for a finding that less than 2 factors are present.
But also it says after considering the factors. So that's all the factors. So I think you said they wouldn't be able to consider the other factors. So I don't think that was a correct assessment. But thank you for your testimony. We need to move on. Is there any other discussion? Representative Burke.
Thank you. Based on the committee sub, which we received today, and the lack of an updated corrections impact statement, I'm going to make a motion until an additional updated corrections impact statement is received.
Is there a second? There's a second. Any discussion? So the chair would advise the membership to vote against this motion, to vote no. The reason that there was an email that was sent out this morning at 8:49, and the reason that the sub was delayed was because of technical issues yesterday for anybody who was here, and the staff did the best that they could do, and I appreciate the work that they've done all session. So there's a motion, there's a second. I would advise voting no, and Mr. Clerk, please call the roll.
Representative Banta.
No.
Representative Blanton. Representative Bratcher.
No.
Representative Bray. Representative Burke.
I'd like to explain my vote.
Yes, please.
We are here in a budget session. This is the time when we need to be most focused on our finances. And to move this bill forward without the correct procedure would either require a suspension of the rules or we don't do it. We need to follow our own rules. The people expect this. The people deserve this. And so I'll be a yes. We should table this until we have correction as an impact statement updated.
Representative Dietz. Representative Down. Representative Flannery.
No.
Representative Herron. Representative Kulkarni.
Yes.
Representative Lewis. Representative Maddox.
No.
Representative Mosier.
No.
Representative Nemus. Representative Petrie. Representative Rawlings. Representative Sharp.
Nay.
Representative Stevenson.
Explain my vote.
Please go ahead.
We are in a budget session, and we don't have a place in Louisville to put juvenile defenders. We won't put the resources to making sure they get what they need and they have a place to house them. So why don't we have that information, and why are we pushing forward without the ability to affect this bill? So yes.
Representative Wilson. Representative Decker.
Yes. I'm no. I'm sorry. I'm no. I'm a no.
Chair Elliott.
No. And I'm going to recognize Representative Dietz. I think she needs to vote. And she's a no. So the motion to lay the bill on the table fails. There's a motion and a second. Let me get my bearings here. So there's a motion and a second to adopt Senate Bill 20 as amended by the committee sub. Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Explain my vote.
Yes, please.
If I believed this was going to make a difference, I would support it wholeheartedly. But this is not the pathway forward. As one of the opponents testified, you can already transfer a case just like this to circuit court. You don't need this bill to do it. I'm a no.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan. Representative Flannery.
Yes.
Representative Herron.
May I explain my vote?
Yes,
I
you
am
may.
going to be a no, and I just want the senator to know, if we want to talk about the price tag of what we need to do, the price tag is having more background checks for access to guns. The price tag is holding gun owners accountable for not securing their guns. And also, the price tag is ensuring that we have more services for mental health for those 120 JCPS students who have been wounded. Thank you.
Representative Kulkarni.
Briefly explain, Chairman.
Yes, please.
I'm going to be a no today. I don't think there's anybody that would argue that we are experiencing an epidemic of gun violence, but this bill does nothing to keep guns out of the hands of our juveniles. Treating juveniles as adults is not an evidence-based tactic. Locking them up for longer periods of time without those wraparound services that were mentioned is not going to keep them from committing further offenses. It's not going to keep our community safer. We do not have the money or the capacity to actually implement this legislation. And for all of those reasons, and until we actually address the root causes of gun violence, these types of bills are not going to help keep our community safe. So I'm a no today.
Representative Lewis. Representative Maddox.
Yes, yes, you may.
Representative Mosier.
Yes, I'd like to explain my vote if
Yes,
I may.
please.
I'd just like to point out that we have invested millions in a new facility in Louisville for juvenile justice. I've worked with the gentleman from Jefferson County on juvenile justice issues. We have wraparound services that are being implemented in these facilities. We have prioritized doing assessments and even multi-system therapy. We have a lot of programs that are going on simultaneously. This is only a piece of the puzzle. So I'm a yes today, and I just wanted to point out that we are very aware of the need for wraparound services. So thank you.
Representative Nemus. Representative Petrie. Representative Rawlings. Representative Sharp.
Yes.
Representative Stevenson.
Explain my vote, please.
Yes, you may.
I am a no today. And what we really need is to make sure that they don't have guns to shoot. Let's try that. This is a Band-Aid, a needed Band-Aid, because bad people need to be held accountable. It's a needed Band-Aid, but you're not addressing the rest of it. And we think we're doing something by not addressing the infiltration of the multitude of guns in my community. Try that.
Representative Wilson. Chair Elliott.
Aye, and I briefly explained my vote. When a juvenile commits a serious crime with a gun, a Class A, B, or C felony, they need to be held accountable. And one of our chief responsibilities here is public protection. And if we're looking at that public protection, we have to hold those people accountable so that they don't go out and commit further crimes, and hopefully we're able to rehabilitate them in a way that they're able to lead productive lives. So I vote aye, and Senate Bill 20 passes with 12 yes votes, 4 no votes, and no pass votes with favorable expression. Congratulations, Senator. Before I adjourn the committee, I do want to recognize our committee staff who have performed so well this session for us. And I want to thank each of you for the work that you've done, and I would like to give them a hand. So if there's no further business to come before the committee, we will stand adjourned.